Good evening, everyone. We're going to start tonight's program in a very short while. We have all the honorable speakers with us. We'd request all of you to please be seated. May I also request our honorable speakers for tonight to kindly take their seats on the dais. Honorable Mr. Justice U. Lalit, former Chief Justice of India. May I please welcome you on the stage, sir. Honorable Ms. Justice Hima Kohli, Judge Supreme Court of India. Mr. N.G. Khaitan, the President, Bharat Chamber of Commerce and Indian Council of Arbitration. May I request you, sir, to please take your seat on the dais. Mr. Arun Chawla, Director General FICCI and Indian Council of Arbitration. We request all of you to kindly stand up for the National Anthem of India.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you so much. Please take your seats, everyone. We also regret to inform that the Honorable Governor of West Bengal, Dr. C.V. Anand Bose, is unable to attend our program tonight, and his office has expressed His Excellency's most sincere apologies for not being able to share the stage with Honorable Mr. Justice Uday Umesh Lalit and Honorable Ms. Justice Hima Kohli. We're honored to have both of them with us tonight, and we'll begin by felicitating them with green certificates. I would request Mr. N.G. Khaitan, the President of BCC and ICA, to kindly felicitate Justice Lalit with a green certificate. Also, let me tell you what the green certificates basically are. This is a pledge from our side. So a grove of 6 trees to be planted in the honor of Honorable Mr. Justice U. Lalit and Honorable Ms. Justice Hima Kohli, each at Trees for Tigers, Sundarbans, West Bengal. Now may I request Mr. Arun Chawla, the Director General FICCI and ICA, to kindly felicitate Justice Ms. Hima Kohli. Respected members of the audience, it gives me immense pleasure to introduce to you a distinguished individual who has made significant contributions to the world of business of law, Mr. N.G. Khaitan, who's the President of the Bharat Chamber of Commerce and a senior partner at Khaitan & Company, a leading law firm in India. Mr. Khaitan has an extensive, long and illustrious career in the legal profession. As the President of the Bharat Chamber of Commerce, Mr. Khaitan has been instrumental in promoting West Bengal's trade and commerce with the rest of the country and the world. Under his leadership, the Chamber has played a vital role in creating a favorable business environment, fostering entrepreneurship and promoting trade relations with other countries. Mr. Khaitan's contributions to the legal profession and business community have earned him widespread respect and admiration. Please join me, everyone, in welcoming Mr. N.G. Khaitan as I request him to give his welcome address. So.
me, it's a red letter day for Calcutta and for Bharat Chamber of Commerce. We have number of programs in Delhi, but after 9 years, we are having a program in Calcutta. So, your Honorable Justice Lalit, former Chief Justice of India, Justice Hema Kohli, Judge, Supreme Court of India, Mr. Arun Chawla, Director General FICCI. I recognize the presence of two judges, retired judges of the Supreme Court of India, Justice Indra Banerjee and Ashok Ji. Thank you very much for being here with us. I also recognize the presence of Your Excellency, the Consul General from China and Russia. I'll also recognize the presence of GOC Bengal, Major General Brahma Rajan. I also recognize the presence of the governing body members from Indian Council of Arbitration who have come all the way from Delhi, Chennai, Kanpur. I also recognize the presence of my distinguished past presidents of Bharat Chamber of Commerce. They are a rare commodity. They hardly attend our functions. So thank you very much for being here this evening, sir. Distinguished guests, Shiv Prasanna ji, thank you for coming here today. So we are indeed really fortunate today that today we have Justice Uday Lalit, an eminent lawyer and former Chief Justice of India. His tenure as a Chief Justice only lasted for 74 days, but it is well known that he started big and started with a bang. After taking over as Chief Justice, he introduced time-bound hearing of cases for timely adjudication and fast-tracked the hearing of constitutional matter. During his tenure, for the first time, 6 constitutional benches were set up and several cases which were dormant got listed. The former Attorney General of India, Justice Mr. K.K. Venugopal, said on his farewell day that over 500 constitutional bench cases which were lying buried were disinterred during his term, sir. The most critical reform which was introduced by Justice Lalit was the commencement of live streaming of the hearing, and which was a historical step which commenced from 27th of September 22. Justice Hema Kohli, while she was a judge of Delhi High Court and also a judge of the Supreme Court, has participated in our conference in innumerable number of occasions. In fact, she was there in Dubai in our international conference in the month of March last year. She was one of the judges who passed an order during COVID-19 that the COVID test must be done within a period, the test results must come within a period of 1 day. She also has a connection with Calcutta, being the General Counsel of West Bengal National University of Juridical Science. I have been asking her off and on in our conferences that when will you come to the city of joy, my city, and I'm very happy that today, Justice Kohli, that you have kept my word and you have been in Calcutta today. One of the most important issue where she headed the bench of the Supreme Court, 5-judge Constitution bench, which was on the freebies being given by the political parties. This matter has been referred to the larger bench, but in that particular judgment which has been referred to the larger bench, the 5-judge Constitutional bench have said, and this is very important, the state government cannot provide basic amenities due to the lack of funds, and the state, this is an account of freebies, and the state is pushed towards imminent bankruptcy. In the same breath, we should remember that such freebies are extended by utilizing taxpayers' money only for increasing popularity of the political parties for electoral gain. This was her statement in that particular judgment, and that has now been referred to larger bench. So many, many thanks for your such statement. I am also really grateful that today we have I have no words to say that we got Justice Lalit to come here and speak today with us, and also so I welcome them to the city of Calcutta. Now, as a Chamber of Commerce and an Indian Council of Arbitration, you might ask me that why I have chosen this subject. We basically belongs to the business community. So why this subject, that independent judiciary is critical for vibrant democracy? I was thinking aloud. A lot of people asked me that as a Indian Council of Arbitration, you are not having a discussion on mediation or arbitration, nor you are having a discussion on growth of business. Why this subject? Sir, we all know that no trade, commerce in industry, nor any arbitration can survive unless we have an independent judiciary and a vibrant democracy. This is, as I say, that the nerve of the industry, the nerve of the business. In fact, Justice Lalit in one of the conferences at Nagpur recently said that our motto in Supreme Court is Yato Dharmostu Jaya. It means, this is also very important, that whatever is right shall prevail, and that this kind of ethos this country stands for, and the judiciary is no exception. Democracy is safe in India, no matter how many assaults are made on it, because the nation is governed by the rule of law, and whatever is right shall prevail. Thank you very much, sir, for this bold statement of yours. Speaking at an event in, I'll skip off the statement by Justice Law Minister Riju, but let me tell you why this conference is so important, because in spite of COVID-19 and uncertain geopolitical environments and the ongoing war, India has emerged as the fastest growing economy in the world, and will continue to remain so for a very long time. We have become the most populous nation in the world, and our consumer market or the consumer basket is the highest in the world today. In a recent Economic Global Summit on 17th February 2023, our Prime Minister said that prosperity of India is the prosperity of the world, and the growth of India is the growth of the world. And on 17th of February, this is only few days back, in 2023, the top CEO of 10 American companies said that they are super optimistic about India, and they are committed to India. Could we have ever imagined that we will place the largest aircraft order in the aviation history? The President of USA and the President of France, in fact, complimented India for providing employment in their country. So that was something unheard of. We are a global player now. It is India's century. In fact, it is a new India. Vice President of USA is Indo-American. Nikki Haley, who has said that she will contesting the election as the President of USA in 2004, is an Indo-American. The World Bank President today is an Indian. The top 30 companies in USA, the CEOs are Indians. So therefore, today we are a global player now. Our population is now the youngest in the world and shall remain so. So we are an aspirational country. Our Honorable Chief Justice, the then Chief Justice, Justice Ramanna, who came to London in our international conference last year in the month of July 2022, said, and he came straight from San Francisco to London and spoke on our conference, and he said, made a very bold statement, and in fact, an eye-opening statement, that 50% of the industry in Silicon Valley are either funded or founded by Indians. 50% of the industries in Silicon Valley are either funded or founded by Indians. We are the largest democracy in the world. We have over 900 million registered voters. And we as an Indian can stand for election either for the state assembly or parliament. We can even stand for Vice President of India. We can also stand for the President of India. So therefore, this is the right which we have. Now, in a recent survey, this is very important, that in a recent survey made by India Today, which was also published on 6th of February 23, there was a survey on the mood of the nation. And one survey was that out of 4 pillars of democracy, which is legislature, executive, judiciary, and media, which is the best to uphold the democratic norms in India, and the majority reported facts on judiciary. Their faith on judiciary was the highest. However, this is also very important. In the same survey, people surveyed about how do they rate the current state of democracy in India. Half of the people in that survey said they are very positive and confident about the democracy in India. But the other half said that the democracy in India is in danger. So this is the reason that, I'm holding this conference today, and this is where the judiciary has to step in. Ever since our independence, judiciary has played a very predominant role in protecting the right of our citizens and their occupation, and has acted as a guardian, safeguarding the life and liberty of its citizens. It has also struck down various legislation vitiating our fundamental tenets, forming basic structure of the Constitution and ensuring free and fair election, rule of law, fair play, and equity. This is also very important. When an attempt was made that the constitutional amendment would not be subject to judicial review, when an attempt was made that the constitutional amendment would not be subject to judicial review, the court stepped in to invalidate such a legislation. Recently, there has been an attempt last year by Prime Minister Netanyahu to do the same thing in Israel, where they said the parliament is supreme and whatever law they make cannot be subject to judicial review, and parliament will only have the power to appoint the judges. There was a uproar in the entire country of Israel. Everybody stood against it. Therefore, this is also very important. When a law was passed that the election of the president, election of the vice president, election of the Prime Minister of India, election of the Speaker of Lok Sabha would be beyond the scrutiny of the law, the same was also struck down by the Supreme Court. On the charge of corruption, various chief ministers, central ministers have been convicted, and the allotment, we have Justice Ganguly here, where he struck down the allotment of 2G and various allotments of national wealth, which on the charge of corrections were invalidated. The right to life has been the lifeline of our Constitution. The courts have always protected the rights of the citizens to the livelihood, to the profession, to the business, to the residence, to the education, to the food, to the reputation, to the privacy, to the phone tapping, right to live and die with dignity, freedom of speech and freedom of expression, including right to know and right to have information. So these are the rights which the Constitution have given us, but which has been protected by the Honorable Supreme Court of India and different courts of India, protecting that right whenever an assault was made by the executive or legislature on those rights. 2 days back, on 2nd of March 23, the 5-member Constitution bench, that is only 2 days back, of the Supreme Court, by unanimous verdict, gave a direction that henceforth the election of Chief Election Commission and the election commissioner by the President shall only be done on the recommendation of the committee comprising of the Prime Minister, Leader of Opposition, and the Chief Justice of India to maintain the purity of election. Sir, today I was, in fact, the last 2-3 days I was asked by a lot of people that I must convey their concern on one issue. And that concern was basically indiscriminate arrest and a right to bail. I mean, this is something which the business community and which is general public are really concerned about, and the bail which takes a lot of time to get. We always say that right to life is so sacrosanct to our Constitution. If the right to life is so sacrosanct to our Constitution, why not the right to bail be a part of that sacrosanct right? why should we have and why should we send people to jail until they are convicted? Or we have some modalities where there is an automatic bail within a fixed period of time of 20 days or 30 days. But I think right to bail is very sacrosanct to the right of life, and I thought I want to convey this message. Sir, we are marching towards the third largest economy of the world, and we would be soon overtaking Germany and Japan in the next 5 years. Sir, with our purchasing power parity, we are the third largest economy in the world. We have the Council General of China, sir. We are marching with you. You are the second largest. We will be the third. So we will need your support and help all the time to be there with you. Sir, there was a recent survey again on the mood of the nation. Are we a happy nation? And I'm very happy to state that 70% of the Indians said either they are happy or they are somewhat happy. So this made me so happy that, this is what the Indians feel about. And then it is our duty to maintain this happiness and to maintain this momentum of growth and the prosperity of nation. And to that, I think both judiciary and legislature have to play a complementary role so that there is no attempt to encroach upon the independence of judiciary and at the same time to ensure that our democracy remains vibrant. Sir, there have been occasions when judiciary, executive and legislature, all the three, have crossed Lakshman Rekha. We cannot dispute that. But then this is a natural phenomenon in our life. We all in our personal life cross Lakshman Rekha. Everybody of us. But then we correct ourselves in time to come. It is not that if a wrong is done, then we correct ourselves. Both in our personal life and the same also happens. So sometimes we criticize the judgments of the Supreme Court. Sometimes we criticize the action taken by the Parliament. Judiciary is there to decide which is right and which is wrong. And then we correct ourselves. Sir, with the public interest litigation, we have become a people's court. I mean, this is the only action available in India. No part of the world have this particular legislation. And with this, anybody can, by writing a simple letter to the Chief Justice of the High Court or judges of the Supreme Court or the Chief Justice of Supreme Court, any person from a weaker section of society can take up a public issue. And that is the reason that we always say the court is a temple of justice. And then it is in our interest that we protect the honor and the dignity of our temple of justice, including the executive and legislature. Thank you very much, sir, for the patient hearing. Thanks a lot.
Thank you so much, sir. Honorable jurist, dignitaries, members of the legal fraternity, and other distinguished guests, it is my distinct pleasure now to introduce to you Justice Mr. Uday Umesh Lalit, an eminent jurist and former Chief Justice of India. Justice Lalit is one of the most respected and renowned jurists in India with a distinguished career spanning several decades. He has served as a judge in various courts across the country and has made significant contributions to the Indian legal system. In addition to his contributions to the legal system, Justice Lalit has also been recognized for his commitment to public service. He has been involved in various social and charitable initiatives and has worked tirelessly to promote access to justice and uphold the rule of law. Today, we are honored to have Justice Lalit with us, and we look forward to hearing from him about his experiences and insights on the Indian legal system. I'm confident that his words will inspire and enlighten us all. Please join me, everybody, in giving a warm welcome to Justice Uday Umesh Lalit.
Honorable Justice Hima Kohli, Judge, Supreme Court of India, Honorable Justice A.K. Ganguly, former Judge, Supreme Court of India, Honorable Justice Indira Banerjee, former Judge, Supreme Court of India, Mr. Khaitan, Mr. Arun Chawla, the Learned Counsel General for China. I see some of the senior advocates here from the Supreme Court, and all dignitaries who are present here, some of the captains from Indian industry, ladies and gentlemen. Calcutta is known to be the capital of what we call the intelligence in the country. Whatever thoughts are expressed in this city in Bengal today, perhaps I think the rest of the country follows it tomorrow or day after. I had an occasion to visit Shantiniketan about a few months back. And right at the entrance of the gallery, there is a expanded version of the handwritten one page by Gurudev Rabindranath Tagore. And that sums up what the society ought to be, what the fraternity, what the brotherhood has to be, and what we owe to every single individual in the society. I can't do anything except read out what the actual expressions used by Gurudev are. Please permit me to read that out. What he said is, where the mind is without fear and the head is held high, where knowledge is free, where the world has not been broken up into fragments by narrow domestic walls, where the words come out from the depth of truth, where tireless striving stretches its arms towards perfection, where the clear stream of reason has not lost its way into the dreary desert sand of dead habits, where the mind is led forward by thee, this is what the prayer is to the God, into ever-widening thought and action, into that heaven of freedom, my Father, let my country awake. And that's a very beautiful thought, that what should the country be like, where there is independent thought, where there is freedom of expression, where there are these freedoms. What else is Universal Declaration for Human Rights? What do we say in our country? What is Maneka Gandhi ultimately? That one must have an environment, a society where every individual is free to develop his or her potential to the fullest. That kind of environment must be assured for every individual, and that is part of your right to life. If that's the expanded form of right to life, every society must have these minimum assurances. What Gurudev Rabindranath Tagore put it so beautifully. Very well, idealistically, yes. But at times there are struggles, at times there are skirmishes, at times there are disputes, at times there are differences. How does one resolve them? And in order to resolve any disputes which arise in the society, one arm of the apparatus of government or the state is nothing but the judiciary. What is normally said is that in order to have a thriving and surviving democracy, one must have independent judiciary. Why? Because it is through dispute resolution that the society is assured of orderly behavior and governance by rule of law. What do normally attributes what we associate with independence of judiciary? Impartiality? Yes. Fairness in action? Yes. Reasonableness? When it comes to disposal of matters, when it comes to application of principles to have the dispute resolved? Undoubtedly, yes. Must be complete integrity so far as the purpose, which is dispute resolution, so far as all the players who are involved in dispute resolution. That sums up what independent judiciary is or should be. Our Constitution has recognized and has given us an apparatus. Mind this, the district judiciary is not under the control of anybody else except the high courts in the state. All their postings, promotions, appointments, and even transfers are supposed to be only at the recommendation of the high courts. So that's where we start, right from the foundation, right from the base, that there should be no outside interference with the functioning of the judiciary. Even at the level of the high courts and Supreme Court, which is what we call superior judiciary, number of articles in the Constitution assure and ensure that there is no interference with the functioning of every individual judge or the judiciary in general. The conduct of a judge can't even be discussed, even on the floor of the House. So that's the kind of independence that we have ensured so far as all judicial officers are concerned who are manning the superior judiciary. They can't be touched, they can't be even proceeded against except when a motion for impeachment is actually discussed by the representatives of people. That's the kind of assurance, that's the kind of guarantee, independence which is afforded by the Constitution, by our founding fathers. So one way to ensure independence of judiciary is to have an atmosphere where the persons who are charged with the duty of discharging judicial functions must have that sense of complete freedom and lack of interference from any agency. That's of course there. There have been attempts where generally the decisions of the courts have at times been made subject to executive interference. One of the classic cases is P. Sambamurthy, where a constitutional amendment which said that the decisions of the adjudicating body shall be subject to the executive directions. That constitutional amendment which gave that particular leeway or window to the executive when it came to tribunals was struck down by the Supreme Court. On what ground? Again, independence of judiciary. This independence of judiciary we have elevated to such levels that it is part of what we call inviolable principles with which the entire society must function, which is normally called the basic structure doctrine under the Constitution. It is this very principle which was taken resort to by the courts while striking down one of the later amendments to the Constitution which introduced what is called National Judicial Appointments Commission. That's the level to which we go. Mr. Khaitan was right when he said that I had referred to Yato Dharmas Tato Jayaha. That is the emblem, or that's the motto of the Supreme Court. Just before the Mahabharat war, Duryodhan went up to his mother and sought her blessings. Gandhari could have given the blessings Vijayi Bhava or Yashasvi Bhava to her own son. But the Ashirvad that she gave was Yato Dharmas Tato Jayaha. That is, the right shall prevail. If you are right, you will succeed. But if you are not right, not in the right direction, then sorry, you must perish. That's the kind of Ashirvad which was given by the mother to the son. No fear, no favor. That's motherly love on one side. But what must come from within as a citizen is what Gandhari came out with, that Yato Dharmas Tato Jayaha. And rightly so, our Supreme Court motto is nothing but Yato Dharmas Tato Jayaha. And that's what the judiciary stands for. That's what the entire apparatus must stand for. If that's the idea, every action must be galvanized in that direction. There are various challenges which the judiciary has to face today. And Mr. Fali Nariman, in one of his writings, said very beautifully, a citadel never falls except from within. So therefore, we have to be strong as a judicial fraternity, as a judicial apparatus, as a judicial system. We must bear every kind of pressures, onslaughts, or any kind of interference, and come out completely clean and with a direction, with a sense of purpose that yes, this is what judicial administration requires. One of the challenges which are presently being faced is docket explosion and delays in disposal of matters. These are, of course, yes, these are demons now, present-day demons. We have to find solutions to get over these problems. And every sort of, collegium meeting or the meetings of the administrative judges on the administrative front, we are trying to come out with solutions to get over these problems. I must also say that when you say that the citadel never falls except from within, and that kind of expression is something with which we must protect what is our district judiciary. Our district judiciary today comes under tremendous pressure. As compared to superior judiciary personnel, the persons manning the district judiciary, unfortunately, for them the life is very, very tough. They may pass certain orders which may not be to the liking of the person sitting in appellate jurisdiction. But we must be very, very slow when it comes to making comments upon the conduct of such judicial officers, unless and until we are completely sure, as a policy, as a practice, we must avoid making any kind of comments upon the conduct of the persons manning the district judiciary. I'll give you one classic instance which happened in Bombay High Court way back, almost 50 years back. There was a very good judge in the City Civil Court. And one of his orders was challenged before the High Court, and during the course of the proceedings, certain comments were made by the learned judges, very illustrious judges. But unfortunately, the comment was made, which got widely publicized in next day's newspapers. The judge concerned, City Civil Court judge, immediately resigned. And in his resignation letter, he said that if my High Court doesn't consider my judgments or orders to be perfect, I have no right to continue in my post. Now, that's the kind of onerous job that the judges have to perform. Every time you're always susceptible, you are vulnerable to every attack, every opposition. And that citadel must stand strong every time. As a judicial family, as a fraternity, we must always be together. This is, of course, the internal part of the mechanism or the apparatus of judiciary. The external onslaught, if it comes from any other quarters, of course, yes, we are willing to share that burden, and our shoulders are quite strong and can bear that particular onslaught. Mr. Khaitan referred to certain ideas of what we call the overstretching of what is called separation of powers, at times overstepping certain limits. That's also one of the criticisms which is leveled at the judiciary. But these matters are required at times, without which it will be impossible for the judiciary to function in the most orderly way. Take, for instance, Madhuri Patil, where persons not belonging to reserved communities would masquerade themselves as somebody belonging to that community and corner the admissions and the other benefits. There was no system where it could be checked. The directions were issued by the Supreme Court saying that yes, there shall be scrutiny committee in every district. And such kind of approach, or if I may use that expression, milder one, overreach by the judiciary, was so well accepted that today all the statutory enactments in most of the states carry the same principle. Similarly, harassment of women at workplace, Vishakha guidelines, again has become now something like locus classicus, and it has been adopted in our statutory regime. One of the classic cases is actually Mohini Jain and Unni Krishnan, where interpreting right to life, as I said right in the beginning, Maneka Gandhi, right to life is what? Right to life is to enable an individual to attain the fullest of his or her potential. Then naturally, education is the light towards that. What we say in Sanskrit, tamaso ma jyotirgamaya, asato ma sadgamaya. So therefore, from the darkness to the light or enlightenment, that's the journey, that's the travel, which an individual is empowered to do with the help of education. And therefore, the Supreme Court said, right to education, primary education, is also part of fundamental right. The declaration by the Supreme Court came first, and the amendment by the Parliament came later. So it's not as if that judicial overreach on every occasion has been criticized or adversely commented upon. It is something, the steps have been welcome as a guiding light in a particular direction, and they have been adopted. You are all captains from industry. What is Motilal Padampat ultimately? Promissory estoppel. That if a particular regime has been promised that it shall be in existence for a while, based on which somebody changes his or her position, then the government will not be allowed to change the regime, will not be allowed to take the carpet from under your feet. That's nothing but promissory estoppel. That's again a judicial invention. So these are inventions, these are ideas, these are modalities with which judiciary has always strived to tackle the problems, to tackle the differences, disputes, and come out with finest solutions. And that, ladies and gentlemen, is the function of the judiciary. If you want to have a striving democracy, if justice is to be cheap, if justice is to be without any efforts, if justice is to be clear, then judiciary has to be independent. There is no substitute for that. Thank you so much.
Thank you so much. What brilliant insights to take home to, what brilliant principles to live by. Ladies and gentlemen, our non-binary guests, it gives me great pleasure to introduce Justice Hema Kohli, a distinguished and accomplished jurist of the Indian Judiciary. Justice Kohli has always been widely acclaimed for her judicial acumen, sound reasoning, and unwavering commitment to justice. Apart from her judicial duties, Justice Kohli has also been actively involved in various social and philanthropic initiatives. She has been a patron of several organizations working for the welfare of women, children, and the underprivileged. In recognition of her outstanding contributions to the legal profession and society, Justice Kohli has received numerous awards and accolades. We are honored to have her with us today, and I'm confident that her insights and perspectives will enrich our understanding of the law and its role in shaping a just and equitable society. Please join me in welcoming Justice Hema Kohli.
A very good evening to all of you. Justice U.U. Lalit, former Chief Justice of India, Justice Ashok Ganguly and Justice Indira Banerjee, my seniors, Mr. Khaitan, President, Bharat Chamber of Commerce and Indian Council of Arbitration, Mr. Arun Chawla, Director General FICCI and ICA, respected members of the diplomatic community, the legal community, the industrial houses, ladies and gentlemen, friends from the media. I must start by thanking FICCI and Bharat Chamber of Commerce for organizing this symposium in Calcutta. And I'm delighted to be here in the city of joy after quite a while. Indeed, it's joyous always to come back to Calcutta, to walk the streets, which I did probably this morning just for a bit, and got the flavor of all that Calcutta holds for us, culturally, intellectually, socially, and such a forward-looking society. It's always a delight to be here. So, the subject has been introduced by Mr. Khaitan and is expounded on by Justice Lalit, Independent Judiciary, critical for a vibrant democracy. I'll pick up the strings from Justice Lalit and weave it for you. Independence of judiciary is not just a principle, but a moral imperative. The relevance of an independent judiciary cannot be overstated, especially in a country like ours, which is not just a democratic republic. It has been described in the Constitution as a sovereign, socialist, secular, and democratic republic. We are all aware of the critical role that an independent judiciary plays in upholding the rule of law and protecting the fundamental rights of citizens. The judiciary is also known as the conscious keeper of the Constitution. Its independence is pivotal for a smooth governance of a democratic society. This evening, I propose to discuss the importance of an independent judiciary in the Indian context by highlighting some of the challenges faced by the judiciary of this country in the past and the manner in which it has evolved over several decades to maintain that independent stand in the face of diverse challenges that have been thrown at it. Touching upon the evolution of the concept of judicial independence, During the 17th century, Europe, following a tussle for supremacy between the monarch and the parliament, both had sought cover under the law, which brought the judiciary into sharp focus, since it was alone competent to demarcate the functional boundaries between the privileges of the crown and those of the parliament. This situation gave birth to the doctrine of what we call judicial independence. Gradually, as the society evolved, conflicts arose naturally amongst the constituents, and hence the need for an independent and impartial, competent body for conflict resolution that would enable peaceful coexistence. In modern times, this arbiter of law is known as the judiciary. So, the concept of an independent judiciary is considered to be twofold. One is the institutional independence of judiciary, and the other is the individual independence of the judiciary. Institutional or collective independence of judiciary means that the judicial setup, or what we call the judicial institution, is independent as a collective whole, excuse me, as a unit. Individual independence judiciary, this term implies that every judge is free to decide matters before her or him in accordance with their assessment of the facts and understanding of the law without any improper influence, inducement, or pressure, direct or indirect, from any quarter for any reason. The judiciary's role of acting as a check and balance on other wings of the state is a key aspect of democracy. It's the power of judicial review that allows it. Thank you so much. Thank you. No, it's not there. It's okay. I'll take it back. Thank you. That allows it to declare legislative enactments as constitutional, as unconstitutional, and strike down executive actions that are in violation of the law. The judiciary's ability to interpret and apply the law impartially promotes the legitimacy of the democratic institutions and protects citizens' right to freedom. The judiciary's function of providing checks and balances on other branches of the state is decisive in preventing concentration of power in any one wing by upholding the rule of law and ensuring that the government operates within the remit of its authority. The judiciary promotes stability and effectiveness of democratic institutions. It also protects citizens from arbitrary exercise of power and ensures that their rights and freedoms are respected and upheld. Absent the judiciary's role of maintaining checks and balances, democratic institutions would be vulnerable to corruption, to abuse of power, and erosion, of trust of the citizens of the government. The role of the court in upholding the rule of law and providing checks and balances on other wings of the states makes judiciary that critical pillar amongst the four of democracy. In the context of India, independence of judiciary is something we are discussing today. India has indeed come a long way since it gained independence in 1947. The Constitution, adopted by the Constituent Assembly on 26 November 1949, had laid the foundation of a modern democratic republic based on principles of justice, of liberty, of equality, and fraternity. The Constitution provides for separate powers amongst the three wings, the legislature, the executive, and the judiciary. In fact, Article 50, and if I may quote the article, states, "The state shall take steps to separate the judiciary from the executive in the public service of the state." This provision reflects the need for a clear separation of powers between the executive and the judiciary to avoid any conflict of interest and ensure that justice is not compromised. The judiciary plays a valuable role in upholding the rule of law and protecting rights of citizens. It is the ultimate defender of the Constitution, the arbiter of disputes between citizens and the state. It ensures that the government and public institutions remain accountable, remain transparent, and they adhere to the constitutional provisions. So, as to discharge the constitutional duties, the judiciary must be independent, it must be impartial. This means that it must be free from any external and internal influence. Judicial independence is not just a facet of the fundamental rights of the citizens, but also an essential condition for maintaining a vibrant and democratic social order. The independence of judiciary has been upheld by the Supreme Court in a host of landmark cases, and I propose fleetingly to just give you a flavor of some of them. In one of the famous cases of State of Madras versus Champakam Durai Rajan, which was rendered in 1951, the reservation policy of Madras was invalidated by a stellar 7 majority. In Golaknath, the Supreme Court prohibited the Parliament from amending the Constitution and declared fundamental rights to be the foundational rights essential for development of human personality. In R.C. Cooper, which is famously known as the bank nationalization case, the Supreme Court, by 10-1 majority, rejected the momentous bank nationalization decision. In Keshwananda Bharati, which was heard by the largest ever constitution bench of 13 judges, the Supreme Court, in a 7-6 decision, held that the basic structure of the Constitution, which includes independence of judiciary, cannot be altered by the Parliament, even by a constitutional amendment. In other words, independence of the judiciary was declared as an intrinsic part of the Constitution that cannot be trammered and cannot be tampered by the legislature or the executive. In Menaka Gandhi, a 7-judge bench of the Supreme Court had unanimously extended the breadth of Article 21 and established a live link between Article 14, 19, and 21 of the Constitution. We call it the Golden Triangle, Article 14, Article 19, and 21, or the Trinity, holding that a law that deprives the person of personal liberty must not violate any of these provisions. In Minerva Mills, the Supreme Court reiterated the basic structure document, and the ruling invalidated 2 modifications made to the Constitution to take away the powers of judicial review from the court through the 42nd Amendment, deeming them to be again in breach of the basic structure. In 93 came the Supreme Court Advocate on Record Association case, where the Supreme Court held that judiciary's independence is just not limited to financial independence, but also extends to administrative and functional independence. The court observed that judiciary must be free from any external or internal influence, including from the executive, to be able to discharge its duties impartially. However, independence of judiciary is just not limited to its constitutional status or its financial and administrative autonomy. It is also dependent on the integrity and impartiality of the individual judge who is part of the institution. That judges must remain free from any political, personal, or extraneous influences that may compromise their independence or impartiality. Guided by these principles of justice, fairness, and impartiality, they are expected to be honest to their oath and ensure that justice is dispensed with. And when we take our oath, we say, without fear or favor, affection or ill will. Independence of judiciary in the background of the emergency. In a free country like ours, judiciary has had its fair shares of challenges and controversies. Because of the very nature of the duty required to be performed by judges, the court is drawn into the vortex of having to decide contentious political issues. However, it has demonstrated remarkable resilience and determination to uphold its independence and integrity. The independence of the judiciary was put to a severe test during the period of emergency, which was in the mid-70s, when fundamental rights, including the right to freedom of speech, expression, and assembly, were suspended. Political opponents, journalists, and activists were arrested, and the media was sought to be muffled. The judiciary was not spared from the government's onslaught. In the face of such adversity, some of the judges of the Supreme Court and at least 9 high courts of states had shown remarkable courage and independence. They stood up to the government's attempts to erode judicial autonomy and protected fundamental rights of the citizens. In the famous ADM Jabalpur case, also known as the habeas corpus case, a 5-judge bench of the Supreme Court had to decide the citizens' right to life and liberty could be suspended during emergency or not. The government had argued that the right to life and liberty was not enforceable during the emergency when Article 21 itself stood suspended. The majority of 4 judges held that with their proclamation of emergency and the subsequent suspension of Article 21, no writ would lie in court against detention of a person. The majority held that no person has the locus standi to move the writ petition under Article 2 to 6 before a high court, or issue a writ of habeas corpus or any other writs or directions to challenge the legality of the order of detention in view of the presidential order that was passed at that time. It was Justice H.R. Khanna who had famously dissented from the majority, a dissent, mind you, that costed him the position of the Chief Justice of India. He disagreed with the position that the majority had held that Article 21 can be suspended during declaration of emergency. He was the one who held that if the right to enforce Article 21 is suspended, then there would be no remedy of a person to being deprived of his liberty or life by the state, even though this deprivation might be without authority of law and in flagrant violation of the provisions of law. Justice Khanna's dissenting opinion in the habeas corpus case stands out as a shining example of judicial independence and integrity over time. Though the period of emergency was a low phase in India's democratic history, it demonstrated the resilience of the Indian public, the Indian judiciary, and also highlighted that how important the independence of judiciary is in safeguarding the citizens' fundamental rights, in upholding constitutional values and morality. Much water has flown under the bridge since then, and the hard lessons learned during that time have strengthened the independence of judiciary that has become more transparent and more accountable over period. In recent years, the judiciary has been in the forefront of protecting the citizens' rights, particularly in the cases relating to civil liberties, to environment protection, to gender justice, and such like. For instance, in the case of Justice K.S. Puttaswamy and another, this is the same case that after 40 years of ADM Jabalpur being declared was overruled here, and the dissenting view of Justice H.R. Khanna was upheld as the correct position of law. This was a 9-judge bench of the Supreme Court that recognized the right to privacy as a core fundamental right and an intrinsic part of the right to life and liberty. The case pertained to constitutionality of the Aadhaar card scheme, as we all know, that was floated by the Union of India and which has sought to collect and store biometric data of all citizens. In this historic decision, the Constitution Bench unanimously recognized a fundamental right to privacy of every individual guaranteed by the Constitution within Article 21, in particular Part 3 of the Constitution. It also emphasized the importance of an independent judiciary as a cornerstone of democracy and the rule of law. The case has had significant implications for the protection of civil liberties and the individual rights in India. It has sparked a debate about use of technology and the need for greater transparency, greater accountability in government policies. Since this judgment of 2017, the fundamental right to privacy has been cited as a precedent in many other landmark decisions. Take, for example, the Navtej Sir Johar judgment, where a 5-judge bench of the Supreme Court has unanimously struck down Section 377 of the Indian Penal Code that criminalized homosexuality as unconstitutional. It was held that rights of the LGBT community are entitled to constitutional protection. As recently as on 2nd March, which is just a couple of days ago, as we know, again, a 5-judge Constitution bench of the Supreme Court in Anup Baranwala has held that appointment of the Chief Election Commissioner of India, the election commissioners, should be made on the advice of a high-level committee, as Justice Lalit just shared with you, and so did Mr. Khetan. In fact, I must acknowledge that it was during Justice Lalit's time that several constitution benches were constituted with the idea of clearing the table of long pending constitutional issues that were engaging the courts. And the good work he has done is continuing even today. We have 2 constitution benches running by the road regularly in the Supreme Court. So in this case, the high-level committee has been constituted as a tide over by the court by making the Prime Minister, the Chief Justice of India, and the Leader of Opposition a party to that committee till the Parliament comes up with a law, and the new appointments are regulated by that law. And what did the court hold in that? I'd like to just quote to you some of the observations by the court on democracy. It has been held that democracy is inextricably intertwined with the power to the people. The ballot is more potent than the most powerful gun. Democracy facilitates a peaceful revolution at the hands of the common man, and if elections are held in a free and fair manner. The court also has observed that democracy can succeed only insofar as the stakeholders uncompromisingly work at it. The essential hallmark of a genuine democracy is that the transformation of the ruled into a citizenry clothed with rights, which in the case of the Indian Constitution consists of fundamental rights, which are also being freely exercised. So what could be a better testament to an independent judiciary being critical for a vibrant democracy? The 4th pillar, the media. Media is widely recognized as a 4th pillar of democracy along with the executive, the legislature, and the judiciary. It is a critical component of a democratic society, providing a vital role for promoting transparency, for accountability and free speech, and ensuring that proper functioning of democracy. One of the primary functions of the media is to act as a watchdog for other branches of the state and also to hold those in power and position accountable for their actions. By providing a platform for different perspectives and opinions, the media fosters a vibrant and open democratic society. This diversity of voices is vital to any democracy. It makes sure that the citizens have an opportunity to participate in the democratic process and that their voices are heard. While the media's role in promoting democracy is essential, the judiciary's role in upholding the rule of law remains critical. The judiciary serves as a final arbiter of disputes, ensuring that the law of land is upheld and the citizens' rights and freedoms are safeguarded. On its part, the media plays a significant role in informing the public and facilitating civic engagement. The judiciary plays the part in upholding the law, and that ultimately ensures that democratic institutions remain stable, they remain legitimate and effective. So should media report judicial proceedings? Another question that comes up often. A recent case, the Chief Election Commissioner of India versus Vijay Bhaskar, the Supreme Court held that the citizens have a right to ensure that courts fulfill their role of preventing arbitrary exercise of power. Availability of information regarding court proceedings plays a significant role in keeping the citizens informed. The media's right to report on court proceedings, which are public events, serves the twin purpose of protecting the rights of individuals and entities to report and of bolstering the judiciary's integrity and the cause of justice. It ensures transparency, it ensures accountability of judiciary, and contributes to upholding the principles of democracy. The importance of reporting public proceedings held in open court has been emphasized in these cases to provide vital information about the activities of the executive and the legislature. It is for this reason that the Constitution bench matters are being live streamed, as you all know, so that the public is made aware of how matters of importance are dealt with and of the court's process and the court's procedures. However, as you're aware, not all cases are heard in open courts. Courts do recognize that some cases involve the privacy of parties. Take, for example, cases relating to matrimonial disputes or matters of child sexual abuse. To conclude, independence of the judiciary is not just a legal principle, but a fundamental pillar of a vibrant democracy. The Indian judiciary has shown remarkable resilience and determination in maintaining its independence and integrity and discharging its constitutional duties. It is the responsibility of all the citizens to work towards upholding the democratic values and to strengthen the judiciary, and a corresponding duty of the courts to protect the rule of law and promote an equal and an inclusive social order within the frameworks of the Constitution. In recent times, some concerns have been expressed as to the quality of the constitutional dialogue in our country. At times, the judiciary has been accused of overstepping its boundaries and encroaching on the powers of other branches of the state. Let me assure you that the judiciary is ever conscious of this. The self-restraint it imposes on itself is for the very same reason. It is imperative that all three pillars of the state work in parallel and not in tandem. They work at arm's length and not hand in hand to give strength to the democratic system. This itself will preserve independence of the judiciary and protects its autonomy and impartiality. It is equally essential to recognize the judiciary's role in a constitutional dialogue as it acts like a safety valve for fostering our democratic values. The judiciary must be allowed to interpret the Constitution and make decisions based solely on the Constitution and the laws. It is this interpretation that offers a guarantee for the Constitution to remain a living document that keeps on evolving over time while remaining rooted in its fundamental values and principles. Therefore, having a robust constitutional dialogue in India, where all the branches of the state engage in a meaningful conversation with each other and at the same time respect each other's independence and the respective delineated roles, is the best thing for a vibrant democracy. I leave you with a thought expressed by Thomas Sowell, the American economist and author, and I quote, "An independent judiciary does not mean judges independent of the Constitution, from which they derive their power, or independent of the laws that they are sworn to uphold." Thank you.
Thank you so much, Justice Hima Kohli, for sharing your valuable insights with us. Distinguished guests, ladies and gentlemen, our non-binary friends, it gives me immense pleasure now to introduce to you Mr. Arun Chawla. Mr. Chawla is the Director General of the Federation of Indian Chambers of Commerce and Industry, also known as FICCI, the apex chamber of commerce and industry in India, and also the Director General of the Indian Council of Arbitration, ICA, the apex arbitral institution of India. Under Mr. Chawla's leadership, FICCI has partnered with various international organizations to promote trade and investment between India and other countries, and also been at the forefront of advocating for reforms in India's business environment, and has played a key role in shaping India's economic policies. Mr. Chawla has also played a key role in the establishment and success of the Indian Council of Arbitration, which is the apex arbitration body in India. Under his leadership, the Council has organized several national and international conferences and seminars aimed at spreading awareness and promoting the use of arbitration as an effective alternative dispute resolution mechanism. I have no doubt that Mr. Chawla's insights and experience will be of immense value to us all. So please join me in welcoming Mr. Arun Chawla to this event, and we look forward to hearing his vote of thanks.
Honorable Ms. Justice Hima Kohli, Judge Supreme Court of India, Honorable Mr. Justice U. Lalit, former Chief Justice of India, Justice Indira Banerjee, former Judge, Supreme Court of India, Justice Ashok Ganguly, former Judge, Supreme Court of India, Justice Patharia, former Justice, Calcutta High Court, ladies and gentlemen, I've been given the pleasant task of delivering the vote of thanks on a day when a very significant topic is under discussion: independent judiciary, critical for vibrant democracy. Many complicated questions are hidden behind this prima facie simple topic. Does independence mean complete freedom? Independence from what and from whom? How is this independence to be achieved, and what is the purpose of it? India has a dynamic, vibrant democracy where the doctrine of separation of powers is followed, but with checks and balances. In such a governance model, the independence of judiciary starts from the appointment of judges till their retirement. Role of government in appointing judges has been and still is the topic of debate since the first judge's case in 1982. The matter came up twice, again before the courts. The NGAC bill was passed, but the debate continues. Courts strive on the strength of public trust and confidence. It is not created in a single day. Trust is generated by the role the judges play. Trust is generated when judiciary is able to decide the matters before it in a non-discriminatory, fair and reasonable manner. This is possible if the judiciary is impartial, free from any influence, inducement, pressure, direct or indirect. It is equally significant. This independence is multidimensional and multifaceted for the judiciary to function at its qualitative best. There must be functional independence, personal independence, internal independence within the judiciary, as well as collective independence of the institution. Rule of law, ladies and gentlemen, is considered as the bedrock of democracy, and Professor Dicey, the founder of the doctrine, enunciated that independent judiciary is the sine qua non for rule of law. It is the protector of rights of individuals with inherent powers of judicial review, of administrative action and legislation. Time and again, the power of judicial review has been considered as the basic structure of the Constitution. Judiciary is thus considered as the strongest pillar of democracy, which strives to maintain the rights of people, uphold constitutional values, and thus ensure a government of the people, by the people, and for the people. Today we have eminent jurists who deliberated on these topics. I'm extremely thankful to Honorable Justice Hema Kohli, Judge, Supreme Court of India, a very dear friend, champion of rights of women, first woman Chief Justice of Telangana, inspiration for many. She started her office in the boot of the car to reach the highest court of justice, the Supreme Court of India. Her statement that it is not just the independent judiciary is not just a principle, but a moral imperative, sums up her views on the topic. A big applause for Justice Hema Kohli. A big thank you to Honorable former Chief Justice of India, Justice U. Lalit, who has been the backbone of criminal jurisprudence of India. He has beautifully summed up his views and thoughts on the topic by quoting Rabindranath Tagore. To have a thriving democracy, it is utmost essential to have an independent judiciary. Any outside influence would be surely detrimental to the working of the democracy. So the panacea of the independent working of judiciary is based on the idea that the citadel must not fall from within. must bear the onslaughts from outside. Justice Lalit, your statement, there is no substitute to the independence of judiciary if democracy is to survive. So, ladies and gentlemen, a big applause for Justice U. Lalit. I would like to take this opportunity to thank the former Supreme Court judges, Justice Indira Banerjee, Justice Ashok Ganguly, judges of the Calcutta High Court who have joined us today, and members of the legal fraternity, business leaders, diplomatic community, and of course the members of the media. I would also like to thank Mr. N.G. Khitan, an eminent lawyer, President of the Bharat Chamber and President of the Indian Council of Arbitration. Mr. Khitan has always been a very supportive for all the endeavors of ICA. Thank you, sir. Ladies and gentlemen, I thank you for all being part of this august gathering and making the symposium a success. Thank you.
Thank you so much, sir. I'd request all of you to kindly stand in front of the stage for a group photograph. We'll quickly take a group photo. And I'd request all of you to kindly join us for dinner at Silver Tulip right after this.